Good morning. This is your Kelso Report for Friday, April 13th, and I'm your host, Clark Kelso. Today we have cases arising in habeas corpus, communications law and the First Amendment, meal and rest breaks, partnerships, criminal sentencing, and family law. Let's begin with a couple of Ninth Circuit cases. The first, a habeas corpus decision involving the Speedy Trial Act. Now, 30 years ago, the Ninth Circuit held in Cardin v. Montana that absent specifically defined extraordinary circumstances, principles of federalism and comity, particularly the doctrine of younger abstention, prohibit a federal district court from entertaining a pre-conviction habeas petition raising a speedy trial claim as an affirmative defense to state prosecution. 10 years ago, in McNeely v. Blanus, without discussing Cardin or abstention at all, since the issue was not raised by the state, the Ninth Circuit actually granted a habeas petition raising the speedy trial claim where the state had failed to bring the petitioner to a preliminary hearing or trial over 4 years after charges had initially been filed. Well, in yesterday's case, Brown v. Ahern, the petitioner argued that the decision in McNeely altered the rule in Cardin. The Ninth Circuit rejected this argument, interpreting McNeely as simply involving a case where the state had waived the younger abstention defense to a habeas petition. Since the state in Brown v. Ahern did not waive the abstention doctrine, the Ninth Circuit panel applied its precedent in Cardin and affirmed the district court's denial of the petitioner's speedy trial claim on abstention grounds. Next, communications law and the First Amendment. In a case that I think is likely to catch the attention of the U.S. Supreme Court, a split panel of the Ninth Circuit held unconstitutional a statutory prohibition in 47 U.S.C. section 399B subdivision A against public radio and television stations from transmitting over the public airwaves advertisements regarding issues of public importance or interest and political advertisements. The panel did uphold that portion of the statute prohibiting advertisements for goods and services on behalf of for-profit entities, commercial ads, but struck down the prohibition against public interest and political ads. In reaching this conclusion, the majority applied intermediate scrutiny to the content-based classifications contained in the statute, consistent with long-standing Supreme Court precedent that has applied intermediate scrutiny to regulations of broadcasting, even though ordinarily content-based bans on speech trigger strict scrutiny. In the Supreme Court's 1984 decision in League of Women Voters, it struck down a ban on all editorials on matters of public opinion as applied to public broadcasters, finding the ban was not narrowly tailored to further an important state interest. Following League of Women Voters, the Ninth Circuit majority held that the bans on political ads and ads regarding issues of public importance were similarly not narrowly tailored to further important government interests. The interest asserted by the government was in ensuring the high-quality educational and non-commercial programming broadcast on the public airwaves. The government contended that if public broadcast stations are permitted to transmit paid commercial, public issue, and political advertisements, public broadcast stations would attempt to attract advertising dollars by replacing the high-quality niche educational programming with programming of greater mass market appeal, thereby reducing the quality of public broadcast programming. Well, the Ninth Circuit majority found sufficiently strong evidence in the legislative history of the statute to support the concern that commercial advertisements would harm programming choices. So they upheld that portion of the statute. By contrast, there was no evidence at all to suggest that political ads or public issue ads would have any impact on programming choices, and the absence of this evidence led the majority to strike down the bans on issue ads and political ads, while upholding the ban on commercial ads. Now we turn to the California Supreme Court, which issued its long-awaited decision on meal breaks. Labor Code Section 226.7a prohibits an employer from requiring an employee to work during any meal or rest period mandated by an applicable order of the Industrial Welfare Commission. The primary issue before the California Supreme Court in Brinker Restaurant Corporation versus Hohenbaum was whether this statute and the relevant wage order required that the employer actually make sure that no employees worked during the applicable meal period, or, alternatively, whether it was sufficient that an employer made sure that employees were simply not required to work during the meal period. If the former, the defendant restaurant would be liable for substantial violations because it did permit workers to work through meal periods. If the latter, the defendant restaurant would be largely exonerated because the evidence indicated it did not require work through meal periods. Well, the court held unanimously that the employer's obligation under the statute and wage order was only to relieve employees of all duties, but that employees remained free to use the meal period for whatever purpose they desired, including continuing to work through the meal period. This is a big win for business interests. I would not be surprised to see some action attempted in the legislature to amend the statute. Next, we have a case involving partnerships. According to prior appellate authority, an innocent general partner is not personally liable to a limited partner for the wrongdoing of a co-general partner. The First District held yesterday in Miskey v. Bisno that this rule does not apply when the wrongdoing by the co-general partner consists of fraudulently inducing the limited partner to join the partnership. In these circumstances, the wrongdoing occurs before the plaintiff became a limited partner, and so the general rules of joint and several liability apply to the situation. And in those general rules, the general partner is liable for all of the wrongdoing of his or her other general partners. Next, criminal sentencing. In People v. Kurtenbach, a jury convicted the defendant of conspiracy to commit arson, arson causing great bodily injury, concealing or knowingly failing to disclose an event affecting an insurance benefit, and vandalism. The jury also made true findings that in committing the arson, the defendant used a device designed to accelerate the fire and acted for pecuniary gain. The trial court imposed a prison sentence of 15 years, 8 months. On appeal, the defendant challenged the sufficiency of the evidence, the jury instructions, and the court's imposition of separate sentences for the arson and vandalism. The Fourth District rejected the challenges to the sufficiency of the evidence and the jury instructions, but agreed that the arson and vandalism convictions arose from the same indivisible course of conduct, and under Section 654 of the Penal Code should not have resulted in separate consecutive sentences. The court ordered that the 8-month sentence for vandalism be stayed and otherwise affirmed the convictions and the sentence. Next, we turn to a family law decision involving dependency. The dependency court sustained allegations that one Jose C. Sr. had sexually abused the 11-year-old daughter of a cohabitant, and that the child's mother knew of that abuse but failed to take action to protect the child. As a result, the court found the victim of the direct abuse and her siblings in the family home were at risk of physical and emotional harm, including a risk of sexual abuse. The father argued on appeal that the findings were based on evidence that was incompetent, not credible, and insubstantial. Well, as you all know, attacks against sufficiency of the evidence, and particularly claims that evidence presented below was not credible, are about the weakest points to make on appeal, and this case was no different. The only plausible claim on appeal was that the minor who testified was not competent. But, having failed to object to the testimony at trial, this point also was insubstantial on appeal. As a result, the Second District held there was plenty of competent evidence in support of the trial court's finding. And that's it for today's Kelso Report. Have a great day in the law and a good weekend.